Hello friends, this is Viraj from GS Core and today we will be dealing with questions of current affairs. Those questions of current affairs, the ones that have origin in the subject of Indian polity. Alright, so the first question that we are looking reads, consider the following statements about preventive detention. Now what is preventive detention? Preventive detention is when a person is arrested before he commits a crime, before a crime is committed by him. All right, the motivation of preventive detention is to stop a person from committing a crime. All right, opposite to this is punitive detention. What is punitive detention? Punitive detention is when crime is already committed and after that police arrest the person. All right, and after that police arrest the person. That is punitive detention. So Indian Constitution allows both preventive and punitive detention. All right, so let us look what the examiner needs you to know with respect to punitive detention. So it wants you to look into two statements, and which are those two statements? The two statements are National Security Act and Public National Security Act and Public Security Act are the laws on preventive detention in India. All right, this particular statement is not wrong. These two laws relate to preventive detention in India. There are other laws also. For example, there is MISA. All right, there is ISMA. Okay, these are the laws that are related to preventive detention, that will stop you from doing something which is considered to be a crime. These laws will stop you from committing an act which will lead to act of crime. All right, second statement, Public Security Act is applicable only in Jammu and Kashmir. All right, this particular statement is also right. All right, this particular statement is also right. So our answer will be both 1 and 2. Answer will be basically both 1 and 2. What we'll now do is, let us get into some details of National Security Act and Public Security Act. Why? Because it will help you in gaining the understanding of these two acts, and it in turn will help you if question arises from both of these acts. We are considering these particular questions from the point of view of current affairs, and if you look into current affairs of UPSC over the period of time, what they have started doing is they have started asking you indirect current affairs. That is, if National Security Act is in news, they will ask you something related to National Security Act. All right, that is why we have picked these questions, and that is why we have picked these particular areas of discussion. All right, ठीक है. तो सबसे पहले we will look into what is National Security Act, NSA. So NSA was a law that came up in 1980. That came up in the year 1980. All right, second thing, what does NSA do? NSA empowers both central government and state government. Central government and state government to detain a person who through his act may disrupt public order, that is law and order situation, who may disrupt law and order situation, or he may be hindrance in supply of basic commodities. These are the two reasons under which NSA can be enforced by central government or state government. Who has the power to enforce it? Who has the actual power of enforcing it? Which officer, which statutory officer or which legal officer has the power? So it is either district magistrate or divisional commissioner. So these were some facts with respect to NSA which are important from examination point of view. Now let us talk about Public Safety Act. If we talk about Public Safety Act, so first and foremost, we have learned from the question itself that Public Safety Act is only applicable to the state of Jammu and Kashmir. This is the first important point with respect to Public Safety Act. Second, Jammu and Kashmir is now not a state, it is now a UT. But when it was a state, this particular act was promulgated at that point of time. It was promulgated in the year 1978. Not important from polity point of view, dates are not so important, but still, it was promulgated in the year 1978. According to this particular act, any person who is above the age of 18, okay, that person can be arrested and kept in detention if that person causes threat to security of the state, not a state now, of course, it is union territory, to the security of union territory of Jammu and Kashmir, and or he causes threat to maintenance of public order, so these are the two things under which NSA can be used. A person who is these are the two reasons under which a person can be detained under Public Security Act, not NSA. NSA we have done under Public Security Act. With respect to Public Security Act, remember one more thing, that under this act, the law and order agencies or the police, they can keep a person in detention for 2 years without trial. For 2 years without, for 2 years without trial. Alright, moving ahead. This particular law was brought in by Sheikh Abdullah, the former Chief Minister of Jammu and Kashmir. It was brought in by Sheikh Abdullah to prevent timber smuggling. Alright, that was the original motivation behind promulgating this particular act. In fact, in 2018, an amendment was brought in with respect to Public Security Act, and according to this amendment, a person who is detained in Jammu and Kashmir or who is arrested in Jammu and Kashmir under Public Security Act can be detained in any other state of India. Alright, as we have already seen, answer to this question is both 1 and 2, and we have also discussed fact related to Public Security Act and National Security Act. Moving beyond this, now what we will do is we'll get to the next question. Next question is based on Enforcement Directorate. So let us talk about this particular. Let us look into the question options and then let us talk about the facts related to Enforcement Directorate. So Enforcement Directorate is responsible for enforcement of which of the following acts? Enforcement Directorate is responsible for enforcement of which of the following act? Basically what the question is asking is, under which act does Enforcement Directorate work, or which acts give power to Enforcement Directorate? The first option is Prevention of Corruption Act 1988. Absolutely not, because with respect to corruption we have two bodies. One is CBI and other is CVC. In fact, CBI works under CVC when it comes to corruption. Alright, so it is not Prevention of Corruption Act. Second is Prevention of Money Laundering Act. Yes, this particular statement is correct. Alright, this is one of the laws which gives powers and which entrusts responsibility upon the Directorate of Enforcement. Third we have Foreign Exchange Management Act. This is again the right answer, because basically it is Prevention of Money Laundering Act and FEMA, that is Foreign Exchange Management Act, which give power and responsibilities to the Enforcement Directorate. Fourth statement is Black Money and Imposition of Tax Act. Again, this statement is wrong, because here we have Income Tax Department. This law is enforced by the Income Tax Department. So what is the right option? Which are the right statements of the right laws In this particular case, it is statement 2 and statement 3. So our answer will be B, 2 and 3. Alright, our answer will be B, 2 and 3. If you go through the factual information related to Enforcement Directorate, and Enforcement Directorate has been in news for quite some time now. So let us look into some factual information related to Enforcement Directorate. First and foremost, it is, what is it? It is an economic intelligence agency. Alright. And it works under Department of Revenue, Ministry of Finance. It works under Department of Revenue, Ministry of Finance. And basically, as I told you, it looks into enforcements of two laws. First is Prevention of Money Laundering Act, and second is Foreign Exchange Management Act. So these are the two laws that gives Enforcement Directorate its powers. Primary function of Enforcement Directorate is to control or prevent black money circulation in India, and prevent hawala trade from happening. What is hawala? Hawala is when you send black money out of India. When you send money out of India without the approval of the government, or when you get money in India without the approval of the government, that is hawala. Alright, and most of the time the money involved in hawala, or almost all of the time the money involved in hawala, is black money. Alright, so there is something called as round tripping. Okay. With respect to these two terms, there is something called as round tripping that happens. What is round tripping? Round tripping is suppose I have 1 crore rupees of black money which I have got through corruption, the source of which is corruption. So that 1 crore rupees, it will be difficult for me to use that 1 crore rupees in India, because I will be asked record of it. If I am spending that much money, I will be asked record of it. So what I do something called as round tripping. In round tripping, money from India is carried to a particular tax haven. Okay, it is carried to a particular tax haven. Now tax havens are those countries in which taxation rates are very, very less, and in a way this hawala money is the only source of their income. So taxation rate, because it is very, very less, so what I do is I transfer my money through an hawala agent, through a tax haven, and there a company is set up. In which I am shown to be a director, or my wife will be shown to be a director, or any of my relative is shown to be a director, and this money then will be shown as the profit. This money then will be shown to be as profit that I have earned in that company. All right, in that particular company. And as a profit, as one of the directors of the company, what will happen is this money will come back to me as salary from that company. So company is established only on paper. My money is taken to, for example, Panama, or for example, Gibraltar Islands, or for example, Switzerland. Switzerland now to an extent has stopped this activity, but they are still going on. Or for example, Cayman Islands. Alright, so these are 4 or 5 tax havens of the world. Alright, these are 4 or 5 tax havens of the world. So money is taken from India to Panama. There a company is set up. Alright, I will be the director in that particular company. What will happen is the money will come back to India as salary, because I am the director of that company. So black money goes out and white money comes in. Plus the money that comes in, it is not taxed. Why? Because the money is already taxed in the country of its origin, that is Cayman Island or Panama. Alright, so this money is not taxed. Hence, whatever I earn in black comes back to me as white. I have to pay some amount to agents or agencies that carry out such activities. Alright, and this particular business is very rampant all around the world. So this is what round tripping is. Black money and hawala trade are the two important clutches of round tripping, and this is the thing. Round tripping is the thing which ED wants to prevent in India, or EV wants to completely stop in India. All right, friends, let us look at question number 3. Question number 3 reads, consider the following statements about inner line permit. All right, consider the following statements about inner line permit. So inner line permit has been in news because there was considerable violence in the northeastern part of India with respect to inner line permit. The first statement in this question talks about that it is an official travel document. It is an official travel document that is granted to Indian citizens to travel in protected areas for limited period. This statement is absolutely correct. All right. Inner line permit basically is an official document that is given to Indian citizens so that they can, travel into those areas which are protected for various reasons. We will talk about the reasons. Don't worry about that. It is issued by central government. No, this statement is wrong because inner line permit is issued by state government. And third, it is currently in operation in Arunachal Pradesh, Mizoram and Nagaland. Again, this particular statement is also correct. In addition to these states, inner line permit is also applicable in the states of Meghalaya. It is operational also in the state of Manipur. All right, and in the Union Territories of Andaman and Nicobar Islands. So other than Arunachal, Mizoram and Nagaland, these are the three regions where it is applicable: state of Meghalaya, Manipur and Andaman and Nicobar Islands. So first statement is correct, second statement is not correct, third statement is correct. Now here third statement is correct because the term only is not used over here. If the question was currently it is operational in Arunachal Pradesh, Mizoram and Nagaland only, then this statement would have been wrong. All right, but because this statement leaves space for other states also to be included, as the term only is not used, so what we can say is third statement is also correct. On the basis of this information, what do we say? 1 and 3. All right, statements 1 and 3 are correct, hence our option D is correct. What about inner line permit? So inner line permit, the origin of it is the Bengal Eastern Frontier Regulation. Bengal Eastern Frontier Regulation of the year 1873. All right, so this particular regulation gives us the scope for inner line permit. This is the origin of inner line permit. All right, this particular document, as we have told, it is issued by the state government to Indian citizens to travel in protected areas for the period of 15 to 20 days. During this particular stay that Indian citizens have in these protected areas, they cannot buy property in these areas. This permit is only for the purpose of traveling and staying for a limited period of time. All right. Only for the purpose of limited period of time. All right, moving ahead, why in the first place this regulation, why was in this particular regulation in the first place brought into action? So the reason, if you talk about the purpose, why this inner line permit originated. So first purpose was to have a tab over sensitive areas, to have a tab over who visits, who enters and who leaves the sensitive areas. Most of these areas are border states of India, and most of these areas are those areas in which insurgency is active. Okay, so that is the first reason. Second reason is कि we therefore can manage our international borders in better way. And third, of course, is with respect to protecting the culture of that particular region. All right. So these are the three reasons why inner line permit came into force. Moving on next to the next question. Moving on to the next question. With reference to Chief of Defence Staff, consider the following statement. First statement is he will be single point military advisor to the government. Yes, this particular statement is right. All right. He is the single point military advisor to the government of India and especially to the Prime Minister. Second statement, he will not act as military advisor to Prime Minister on nuclear issues. This statement is not correct. One of the reasons why Chief of Defence Staff, the post of Chief of Defence Staff came into existence was so that Prime Minister will have a specialized military advisor on the defense on the nuclear issue. In defense in general and in specific nuclear issue. So second statement is not correct. All right, and they have in this particular question asked us which statement is incorrect. So incorrect statement is statement 2, hence our answer is only 2, that is B. Now let us look into the specifics of or the factual information with respect to Chief of Defence Staff. So Chief of Defence Staff, as I told you, he in a way is single point military advisor to the government and he is above the three chiefs. He is above the three chiefs. Who are the three chiefs? The Chief of Army, Chief of Air Force and Chief of Navy. All right. Next thing, what is his role? His role is with respect to planning, training, and providing logistics. Looking into logistics issue of all the three forces. He also is someone who coordinates with all the three forces, and he in a way brings all the three forces in parallel when it comes to the defense forces of India. All right. Creation of Chief of Defence Staff is considered to be one of the biggest reforms in the military history of post-independent India. All right, in the military history of post-independent India. Let us go to the next question. In this particular question, the focus is on Press Council of India. Consider the following statements regarding Press Council of India. It is a statutory body. Yes. What is a statutory body? Basically, statutory body is a body that has been created by a law. Law may be of central government or of state government. It does not matter. If a body is created by a law, then that particular body is a statutory body. All right. Moving ahead, example of statutory body, you can say National Human Rights Commission. It is an example of statutory body. Okay. Moving on to the next statement, it has the power to review the functioning of electronic media like radio and television, etc. This particular statement is not correct because it has the power not only with respect to electronic media but also with respect to print media. Not only electronic media but also print media. All right. And Press Council of India, specifically speaking, it does not look into the functioning of electronic media. What it does is it looks into the functioning of print media. Most members of Press Council of India are from press. Obviously, because it is a specialized body, it should have specialized personnel in it. So first statement is correct, third statement is correct, second statement is not correct. Hence what we will say, option B, that is 1 and 3 only. 1 and 3 statements only is the correct option for this particular statement. What we see here is Press Council of India came into existence in 1966. All right, it did not come into existence in 1966. Basically, in 1966, Parliamentary Committee recommended its establishment. All right, So its establishment was in a way recommended by parliamentary committee in the year 1966. It came into existence by Press Council of India Act 1978. 1978. It is a statutory body. We have also seen into it. It is also a quasi-judicial body. What is quasi-judicial body? Quasi-judicial body is a body which looks into disputes and adjudicates. It gives a decision on a particular dispute. That is a quasi-judicial body, but it is not fully a court. Hence, it is not a complete judicial body. It is a quasi-judicial body. That means it does not follow. It does not have to follow procedural code, and Indian Evidence Act. For these two purposes, it can have its own procedure. For the purpose of conducting the procedure and for the purpose of administering evidence, it can have its own set of rules. It does not have to follow procedural code, that is Civil Procedure Code or CPC, and Indian Evidence Act. All right. So that is with respect to the Press Council of India. Press Council of India is headed by retired judge of Supreme Court. All right, what next? There are around 20 members in it. 28 members in it. 28 members in it who represent different press organizations. Different press organizations. All right. Moving on to the next question. Moving on to the functions that are looked into by the Press Council of India. What are the functions? First and foremost, it looks into independence of newspapers, independence of press, that is newspaper, because Press Council of India, as I told you, only looks into print media. All right. Second, it upholds, recommends and tries to uphold code of conduct of newspapers and journalists. All right. Third, it can also look into where a particular news has to be restricted with respect to public interest. So if a particular news can harm the public interest, so Press Council of India in a way can stop that news from coming out also. It can stop that news from coming out also. And of course, last but not the least, it looks into how journalism could be developed in India. Journalism and print media could be developed in India. All right. So here we have seen answer is B. And this is information with respect to the Press Council of India, which you need to remember from examination point of view. Again, moving on to the next question, and this question concerns itself with Disha Act. Which of the following states has recently passed the Disha Act for amendment of criminal law under its jurisdiction? The answer is Andhra Pradesh. The answer to this particular question is Andhra Pradesh. Andhra Pradesh, what it did was it passed Andhra Pradesh Criminal Law Amendment Act. Andhra Pradesh Criminal Law Amendment Act. We'll look into the details of this particular act. What this act says is, First and foremost, investigation of a particular case. Investigation of a particular case should be over in 7 days, plus trial of the case should be over in 14 days. Trial of the case should be over in 14 days. So in all, in 21 days the whole case has to be disposed of. All right, and this particular time boundation has to be strictly followed. It has to be followed in all cases, but mostly in the cases in which victims are children and women. In which victims are children and women. All right, so it has to be looked in. It has to be looked in a more specific way. These particular types of cases have to be looked in a more specific way. Moving on, when it comes to Disha Act, remember this particular act, the name of this particular act has been kept as Disha Act in recognition to a young girl who was raped and murdered in Andhra Pradesh, few years back, it was in 2019. So for the purpose of taping such crimes and bringing justice to the victim and their family, this time period has been set, that is 21 days has been set by the Andhra Pradesh government. Other important issue with respect to this particular act, not issue, other important provision with respect to this act is, under this act, a registry will be maintained of criminals, and this registry will be available to the public. All right, moving on now with respect to one more act, and that is Transgender Persons Protection of Rights Bill 2019. All right, so what this bill wants to do, or what it does, first and foremost, the statement reads, a national council for transgender person is been constituted under it. Yes, this statement is correct. This statement is absolutely correct. Second, some of the transgender persons are provided with the right of residence with parents and immediate family members and be included, and this particular transgender persons will be included in the household of the family or the persons belonging to immediate family. This statement is also correct. All right, both these statements are correct. So this law in a way first and foremost constitutes National Council for Transgenders. We'll look into what this council will do, and in case of some transgenders, what this particular body will also do is, this body will give them right to reside with their parents and members of immediate family. All right, both these statements are correct. Our answer therefore is C1 and 2. All right, our answer therefore is C1 and 2. Let us move into what this law says. First and foremost, what this law wants to do is, it wants to create a non-discriminatory environment with respect to people belonging to transgender community. Second, it wants to provide some rights to transgenders. All right, rights to transgender. It wants to create the identity of transgenders separate from the identities of male and female. All right, transgenders from separate identity of transgenders from those of males and females. And what it also wants to do is, what this law also wants to do is, it wants to create an environment in which transgender people are considered as the persons with special needs when it comes to welfare schemes of government. So when government launches welfare scheme, what the government does it considers some segments of population with extra focus. For example, people belonging to SC community, women. So what this law wants to do is, what this particular law wants to do is, it wants special, when special welfare schemes are drafted, it wants transgender community also to be treated as a commodity, not a commodity, I'm so sorry for the use of that term, that was accidental, a community which needs special help and special focus. All right, special help and special focus. What National Council for Transgender Persons will do? National Council for Transgender Person, what it will do is, it will look into advising the government on transgenders issue. It will also focus on, this particular body will also focus on monitoring the situation of transgenders in the country and provide them with social security and help provide them with social security. This particular act in a way brings into focus the need to reconstitute welfare schemes in such a way that government of India and governments of states are responsive and accountable to the issues of transgender community. All right, to the issues of transgender community. Moving on to the next question, and this question is based on the elections of Rajya Sabha. With reference to Rajya Sabha elections, consider the following statements. Let us look into it. Rajya Sabha election के ऊपर they are asking us question. The vice president is the ex officio chairman of Rajya Sabha. Obviously, this is one of the most elementary questions that you could get. The chairman of Rajya Sabha is always the vice president of India. So this statement is correct. No doubt about that. In fact, the salary that vice president receives, he receives this particular salary as the chairman of Rajya Sabha. As a vice president, he has only one role. If you talk strictly with respect to being vice president, then he has only one role, and that is, to provide services of the president when president is not available. To act as president when president is not available. Otherwise, as chairman of Rajya Sabha or otherwise as vice president, his most important duty is being the chairperson of Rajya Sabha. Next, members nominated by president are persons having special knowledge of economics. No, it is not with respect to economics. So second statement is wrong. Third schedule to the Indian Constitution provides for allocation of seats to the states and union territories in Rajya Sabha. This again is wrong because it is fourth schedule. Alright, the first statement is wrong. First statement is right. Second is wrong. Third is wrong. Our answer therefore is A, only one. What is Rajya Sabha called in English? Rajya Sabha is called in English as Council of State. Council of States. It is the duty, it is the duty of Rajya Sabha to protect the constitutional rights of states. It is also the duty of Rajya Sabha. To look into that if a party has majority in Lok Sabha, it does not use its majority to pass reckless law or to pass laws recklessly. So Rajya Sabha in a way provides a council to the Lok Sabha. Alright. The concept of Rajya Sabha originated by Government of India Act 1919. At that point of time, it was called Central Legislative Council. After independence, Central Legislative Council became Rajya Sabha. Alright, it became Rajya Sabha. Can a person from Rajya Sabha become the Prime Minister of India? Yes. A person who is in Rajya Sabha can become Prime Minister or any other minister. Alright, to become minister in India, you have to be member of either of the houses, or you have to become member of either of the houses after 6 months of you being appointed. In 6 months, not after 6 months, within 6 months of you being appointed the minister. Alright, with respect to nominations, the president can nominate 12 members to Rajya Sabha, and these 12 members need to have special knowledge with respect to literature, with respect to field of literature, science, arts, and social service. So it is not economics, it is these 4 fields. Alright, moving ahead. Consider the following statements about nature of advice by the ministers. Alright, about nature of advice of the ministers. The advice tendered by Council of Ministers. The advice tendered by Council of Ministers to President is binding on him or her. Yes, this particular statement is correct, especially after 42nd Amendment Act. Alright, what 42nd Amendment Act did? It made what was implicit, it made it explicit. So it was earlier implicit that the Council of Ministers, whatever advice they give to the President of India, that is binding. After 42nd Amendment Act, what happened was, after 42nd Amendment Act was passed and implemented, what happens? It became explicit. So now the president is bound by the advice of Council of Ministers. The only thing is that president can once send back advice for reconsideration. Alright, advice can be sent back once for reconsideration. Second is, such advice cannot be inquired in court of law. Yes, again this statement is correct. Whatever the advice is given by the minister to the President of India, whatever advice is given by Council of Ministers to the President of India is under the clause of secrecy. And because it is under the clause of secrecy, even the courts in India cannot ask the President or the minister as to what advice was given by the minister to the President of India. Here both answers are correct. Alright, here both answers are correct. They have asked us to mark the incorrect statement. Neither of the statement is incorrect. So what we will do is we will mark D as the correct answer. D, that is neither 1 nor 2 as the correct answer. Okay, the last question of today. Consider the following statements regarding composite floor test. What is composite floor test? I'll explain it to you. So composite floor test is when in one particular assembly, for example, there is state A. In state A, there are 100 seats in Vidhan Sabha, that is state legislative assembly. And in this state legislative assembly, there are 2 members, that is B and C, both claiming majority. Both claim that they have 51 members supporting them. Alright, 51 members supporting them. In this case, what the governor will do? He will ask simultaneous voting of the members of the Vidhan Sabha for A and B. Alright, simultaneous voting. So the members of state legislative assembly will be given the option of voting for B or option of voting for C. Alright, in this voting, whoever gets 51 members on his side, on his or her side, that person will be declared to be chief minister. That person will be appointed as chief minister by the governor. All right, this is what composite floor test is. Normally, composite floor test takes place when a particular person is the chief minister, but then someone else claims that this person, suppose B was the chief minister, but then C claims that B has lost majority and most of the members are with me. All right, and if the governor is confident that what B is speaking has some essence of truth, then he will call for the composite floor test. All right, then the governor will call for composite floor test. All right, let us look into this particular statement also. Let us look into this particular two statements also. The test is conducted only when more than one person stake claim to form the government. Yes, if there is only one person against whom, the legislative assembly says, suppose B is the chief minister and the legislative assembly says, that members of the opposition in legislative assembly says B does not have majority, but at the same time they don't bring in their own candidate, they just claim that B does not have majority. In that case, what will happen is governor will simply call for something called as floor test. In that case, composite floor test will not happen. All right, in that case only a floor test will happen. On the other hand, if opposition says ki we have members on our side, or we have majority of members on our side, then what will happen? There is a challenge between B and C. In that case, composite floor test will happen. So at least there should be two members. All right, at least there should be two people who say that they have majority. Two or more than two will also be okay. The majority is based on members present and voting. Absolutely. If suppose out of these 100 members only 80 come, 20 do not come, that is 20 abstain, then what will happen? The majority mark will be 41 effectively, because only 80 members have come. All right, so majority is tested based on those people who have come and voted. All right friends, thank you so much for being part of it. Okay, you will complete this. Which of the following statement is correct? Obviously both statements are correct, or answer will be C. So friends, thank you so much for being part of this particular session. We'll meet again soon and we will look into more 10 questions and try to understand both current affairs and polity through those questions. Thank you. Bye.